Welcome, mediators.
I want to welcome all the new ones coming in.
Welcome, welcome, welcome. Welcome, everybody. Southern California Family Mediation sparks change, protects children, and equips families to face conflict more successfully and less destructively. Okay, so there was a robust program in place at the dependency courts for Los Angeles County. And then the budget cuts that started really more like 2009 really sunk in about 2013, they finally closed down the entire mediation program. And the judge at the time, the presiding judge at the time, Judge Lavanis, said to Commissioner Mordetsky, who was the one who just called me a minute ago, to go out and find some people to create a volunteer-based mediation program. And so she reached out to Ken Cloak, and if you recall, Ken Cloak was one of my early mentors, and was kind of a one thing led to another, and that was how I got involved with this program. So in 2014, we're there. The mediation suite is just shut down. Whatever, it's a dark wing. The furniture is in there, but there's no computers, there's no phones. And we just went in there with Commissioner Mordetsky, and we just started figuring out, okay, how are we going to do this? And so she would go up and talk to the judges and start getting us cases. Then we were able to try, okay, and find out, okay, this works, that works, this doesn't work. Okay, we need to mold the program, and, here's how we want to do it. And so we would meet all the time, and we'd have long conversations about how are we going to do this, and what's the process going to look like, what are the procedures going to be, what needs to be in place to make the program function and function properly, and function according to the rules of the court, and function safely for the families, and function for the best interest of the and well-being of the children, and the well-being of the families in general, and making those balances. How are we going to do this? That took a lot of time. 2015 was really our first full year of mediations. And then in 2016, we recruited our first 5 mediators. At that time, there were 7 of us all together mediating. And 2016 was also the first year we did the training. And then 2018 we became a California corporation. 2019 was when we got our nonprofit status, our 501c3 nonprofit status. If you think about the program, it's really proven since 2014, 2015, systemically, the process and the systems and the fact that it works and it serves our families well. However, at the same time, we're a very young program because we've just been a nonprofit since 2019, pretty much right before the pandemic hit. So it's been an adventure, I have to tell you. In the first quarter of 2020, we were on a roll. We had already served 160 families in the first quarter with only 2 no agreements. So we were headed for like a 95+% year based on that. March 13th was settlement day, which started happening. The first time was 2019. And that's when they shut down the entire children's courthouse, and everything is referred to mediation. And also we work in jointly with Loyola Marymount Law School and also USC Law Schools, and we'll serve about 40 families on a settlement day. And then we also do training for the attorneys and the judges. So that's how much the courts value this program, to the extent that they put that on. They give all the mediators awards. Thank you for, doing a great job for serving the families of the dependency court, something like that. A very nice award. Okay, then March 13th settlement day was actually in 2020 was our last day in the courthouse. March 17th, the courthouses were closed. And since we don't work Mondays, we don't mediate on Mondays, that was the first day that, so we just never went back after settlement day, March 13th, which was a Friday, incidentally, Friday the 13th, and that was it. So if you're superstitious, there you go. So as soon as we got the word that they were closed, well, we already had a full calendar of mediations, and we figured our families are going to need us now more than ever. But what do we tell them? We had no guidance from the court, other than don't show up here, you know. And so we met day and night, and we said, what are we going to do? We met Saturday and Sunday and Monday, and we had a lot of meetings. And so the mediators are like, well, I have a Zoom account. We can use my Zoom account. And so we had like 3 Zoom accounts that were just the mediator's private practice Zoom accounts. So we said, okay, so we're going to contact the parents. We're going to give them the links to the Zooms, and then we're going to create these meetings, and we're going to go on and we're going to talk to the parents, and we're going to just find out how they're doing and see what we can do to assuage their fears and help them to come to whatever agreements they can come to naturally and under the current circumstances, without trying to force issues of who's going to be transporting who on the bus and things like that. That, there was a lot of issues that we didn't wade into. And then we rescheduled them. But we heard their stories. We advised them the best that we could. There's such turnover in attorneys, and there's even a fair amount of turnover in judges. Dependency court is hard on judges, and a lot of them, it's not their first choice. And it is. It's 35 impossible decisions a day. So I would go around and hand out mediation information to the attorneys and just remind them or tell the new ones about the program. Hey, we have a mediation program here. And then the amount of mediations that get booked would go way up. And then it would start to drop off because of a lot of turnover of the ladle attorneys. And then so I'd go around in a few months and hand those out again. And so this is kind of a process, and when the courthouses are open, it's really great to go down there and meet the judges and the attorneys and establish those relationships. Being removed like this has been, I think everybody feels a bit disconnected. I mean, I'm sure, people appreciate not having to make the drive, but I think most people feel fairly disconnected. So, good reasons to join the team are if you want to help families through conflict, if you feel like you want to give back to the world. For me, I look at it like this. You have to do something with your time here on the planet. Without getting nihilistic, I say, why not do something cool? So I mean, it's me running on the razor's edge of nihilism, saying, well, I've got to do something with my time. And then saying, why not do something really cool? And this is the coolest thing I could think of. And so that's why I'm here. It's no accident. Good. I'm mediator Randy Drew. I was going along, having a number of different careers, always looking for something. I ended up going to Pepperdine for an MBA and then took a crossover program with the law school in ADR. And I'd never even heard of it, and I'd never even heard of mediation. After that, I was plugging along one day, and I said, well, let me research mediation and see, what kind of careers there are out there. And this was probably a year after graduating. I put in a Google search, and I put in mediation. And Google came back and said, did you mean meditation? And I said, no. And I said, mediation. And they came back with a definition that included the word arbitration, which I even at that point knew was wrong, because that's really the opposite of mediation. People confuse them because they're both forms of assisted dispute resolution. Anyway, I was poking around in a, typical career search. It wasn't terribly exciting. And I came across this article called The Vibrations of Conflict by Ken Cloak. It told me that mediation could be everything that I hoped it might be able to be. And so it just fascinated me. And so I immediately reached out to him. I emailed him. I called the number on the website. And he ended up calling me back from an airport in Beirut. And he said he had some training coming up in October of that year. And so I signed up for the training. And I never looked back. And I had some nice careers, but I was always looking for something more. I really wanted to serve people. It has been an adventure, I can tell you. So it was started in 2014. I was doing this full time for free for 4 years, going to Monterey Park 3 days a week and driving out to Lancaster 1 day a week. And it was quite the adventure. We started building this system, and it's very interesting because it's not one of the systems that was created by a court bureaucracy. We were given the opportunity to create this program from scratch. So it's a mediation program created by mediators, and that's why it's a transformation-based program. Although we do all three flavors of mediation, to be sure, meaning transformational, evaluative, or distributive if we have to, and we also will do facilitative, which is really kind of a mix of the two, I think, or sort of a middle of the road. I've personally mediated for over 900 families, and a lot of times those are saves where I'll come in at the last minute. They've been mediating for 6 hours and the court's going to close in a half an hour, and they say, well, we're not going to get it to an agreement. And at that point I could come in, and I would really say, like, most of the time I could close the deal. And there's reasons for that, but I am very good at this. I carried a personal success rate of 96% for like 1 year. That's very hard to do. As a program as a whole, we've run 92% and 94%, and I'm going to share with you the reasons why. If those numbers seem unrealistic, they are real. We've built the program for you as the mediators to be successful for the family. If you're ready to jump in and change the world with SCFM, then let's go. I want to talk a little bit about the evolution of conflict engagement. Initially, there was power. So going back to even the Stone Age, problems were resolved by who had the biggest army or who had the biggest club. And then as societies got together and grouped together in groups and said, well, we want to do it a different way. We want it to be more fair. So we came up with something we call rights. And rights are actually also a form of power. It's just that the power is distributed different. It's distributed by rights, which, are codified. Now, mediation is a different way of handling it, where we do interest-based negotiation, where instead of saying who's the strongest or what rights do you have, we say, what are your interests, and is there any way that we can help you to resolve this peacefully? In other words, mediators ask why a lot. So, whatever they want, we're going to ask why they want that, because we're digging down to the interests underneath that. Great, let's talk about mediation for a minute. One of the first things we did is we went back and looked at mediation from first principles and said, okay, what is mediation? Now, mediation at its core is voluntary assisted negotiation. It is a form of assisted dispute resolution. Volition is what makes it different from the other forms of assisted dispute resolution. Assisted dispute resolution is what we're really going to be focusing on. Conflict engagement can be negotiation, mediation, arbitration, or litigation. And the three flavors of assisted dispute resolution are litigation, arbitration, and mediation. Negotiation as an unassisted dispute resolution. Ultimately, that's what we want people doing, is negotiating their own agreements whenever possible. Now, when it's not possible, then wise people will reach out for help. And the three forms of assisted dispute resolution, which is what I refer to as ADR, are the choices. And litigation is an adversarial form of assisted dispute resolution that's codified. It's built in such a way that you need representation for most people to navigate the system. And then there's arbitration. And arbitration is simply private litigation. But there's nothing else like mediation. Mediation is the only form of assisted dispute resolution where the people decide their own fates, right? The mediator controls the process, but the parties own the outcome. And you'll often hear me say, never own the outcome. If If you want to sleep at night, don't make it your agreement, it's their agreement. So we will negotiate, we will assist them in their negotiation. So as such, we use terms like multi-partial and omni-partial instead of neutral because we're on everyone's side. And these are some themes you're going to hear me talk about more. You won't hear the term unbiased neutral used to describe mediators in this program, and we'll talk about why that is. One thing I would say about the volition of mediation is, what if it's ordered by a court? Then how is that free choice? Well, you can be ordered to attend mediation, but you can't be ordered to agree to anything or agree to anything in particular. So still, you have the choice. Unlike with litigation where a judge decides or arbitration where an arbitrator decides. Okay, so I want to start familiarizing you a little bit with what we do. And I want to start to get you familiar with the stories of the parents that we work with. Imagine that you're a young parent. You've been attacked by your partner and find yourself lost in a behemoth court system charged with child endangerment. And that would be what would be called a B count, because the child was present when violence occurred, and parents can get charged for that. So this is one of the things that a lot of organizations really hate, and they would like to be able to change it, but there's a lot of reasons it's very difficult. And that is that, let's say a mother, a young mother, can get beat up by a partner, and not only does she have that to deal with, then the police show up and they call DCFS, and DCFS takes her kids away from her. And it seems like she's being punished twice. And maybe she is. However, there's a lot of depth to why that happens. And there's a lot of balance that goes into the thought process of, you can't take every kid from every parent who's not perfect, to when do you find the balance and not get involved and not have kids be harmed. So that's the balance that the system tries to seek. So in this case, you've been attacked by your partner. You find yourself in this behemoth court system and you're charged with child endangerment. You haven't seen your kids in weeks. You're confused and upset, and you hear yourself yelling at your appointed attorney, who has 200 other clients. Your attorney can't hear you because you're screaming, and you can hear yourself screaming, but you can't help it because you're so upset and no one is hearing you. Well, there are 30,000 of you in Los Angeles County right now. Your 2-year journey is going to begin with a disposition hearing, where you may see your kids but not get to talk to them, or you may get to talk to them briefly, or only through a social worker, or only through your attorney. Who, remember, the attorney is not hearing you because you can't help but yell at your attorney who's appointed to you and who has 199 other clients. So their attention is very, very separated. You go through the system, and you're going to take parenting classes, and you're going to take maybe domestic violence for victims classes, and there may be something where you have to do drug or alcohol testing. And then you get towards the end of the system, and it's graduation day, and you're going to be turned out to the world with an exit order that reads, co-parents will agree to a visitation schedule. So now the father of the children, who's maybe not the partner who you are engaged in the violence with, in this case, the father, or is now involved. And so as co-parents, you have to come up with a schedule all by yourselves, and exchange times, and how you're going to communicate, and holidays, and all the details to have a plan, a game plan for how you're going to co-parent together peacefully. But you have no chance of doing this because you've just come out of this adversarial court system where you've been calling each other names and making accusations through your attorneys for 2 years. And sometimes the family members have been put on the stand. So even where there was family before, the family has been torn apart. So now the kids, grandparents hate each other, uncles hate aunts, and everybody hates everybody. And so this is how you're about to be sent out into the system. And so there are numerous places that this program can come in and affect what's happening to this story. In the very beginning, we can do something called settlement conference mediations. These are pre-disposition hearing mediations where we can actually give parents a voice in what charges are levied against them, what language will be used in the charges, which makes a big difference in their family reunification plans. And then during the time when the case is open, when the court has jurisdiction of the children, we can have jurisdictional mediations, at which time we can go in and work with parents, co-parents, who a social worker, a judge, and 4 attorneys can't get the visits to actually take place because these parents hate each other that much. And we can go in and completely transform those relationships, believe it or not. We're famous for that, where attorneys, when we were at the courthouses, would come in and say, is that my client having lunch with the other parent? And things like that. And we would do it all the time. Very transformational program. And there's reasons for why it works. And again, it's very much designed for your success as mediators. Okay. So we do it because peace begins at home, and the dependency courts is where people are when they need us most, at the very moment when they need us most. We also, incidentally, do contested adoptions. There are various different advanced programs that the program does. After you have to do several of the mediations with us before you can really get to the level where you can be comfortable doing that. A little bit about the court system itself is that there are 3 physical locations. The big one is the Edmund D. Edelman Children's Courthouse in Monterey Park. Then there's the new one in Pomona at the Pomona Courthouse. And then there's also one in the Antelope Valley in Lancaster. We have a big office suite in Monterey Park, and then we just have a single office out in Lancaster at the McCourtney Juvenile Justice Center. Okay, a little bit of vocabulary. When we're talking about the attorneys, just to go through them once quickly, excuse me, we're going to be talking about CLC, which is the Children's Law Center, also called Minors Counsel. These are the attorneys that are appointed for every child in the system. Then there's the County Counsel, which is the attorneys for the county who represents DCFS, Department of Children and Family Services. I think a lot of people have trouble saying DCFS, Department of Children and Family Services. So those are the social workers and company. LADLS, stands for, it's LADL, it's Los Angeles Dependency Lawyers, Inc. These are the parents' attorneys. There's about 6 ladle firms and growing, last I heard. The whole system is growing, by the way. There were 21 courts when I joined the system in 2014, and now there's 32, I believe. So it is just booming. Business is good, a little too good. So the ladle attorneys represent the parents. Sometimes I'll use the term conflict partner. Okay, that's for the, anytime people are adversarial towards each other, and that's based on my philosophy of what conflict really looks like, and we're going to delve into that. Custody, generally, there's legal custody and physical custody. What I'm going to say right now is that legal custody is based on decision making, and physical custody is based on where the children spend their time. So our agreements focus on physical custody. There's something called primary residence, or sometimes called primary custody, more properly called primary residence. It's really about where the kids go to school. Okay, what's their school district? If the parents live in this, close enough to where either one of them can drive the kids to school, there doesn't need to be a primary residence. Another thing is their can be no primary residence unless there's joint physical custody, because otherwise it's just sole physical custody. There's no primary residence. That is the primary residence. And the reason I'm hitting on some of these points, because I notice after previous trainings, these are things that don't seem to have registered with the mediators. So you're going to hear this stuff over and over again. Let's see. Multi-partial and omni-partial is in favor of all sides. We use that instead of calling ourselves unbiased neutrals. And I'm going to make a very strong case for why we do that and why I think all mediators should do that. Parties, or a party, is a decision maker in a mediation. That's who actually agrees, as opposed to a participant who may be an attorney or a support person. Let's see. Okay, so we use terms like father or dad and mother or mom. We do preferably first names. But if you don't know their first name, or you find it hard to pronounce their first name, please always ask. You can ask a couple times for pronunciation. Nothing wrong with that. It's just showing the respect of trying to say somebody's name properly. We don't say your ex. You never want to say your ex. Don't assume this. This could have been a one-night stand. We don't say, your husband, your wife. We don't use these terms. Let's see. If we ran into pronoun issues, we would go with whatever made the parties feel comfortable. Our first preference is always first names. In this particular environment, we rarely, almost never, really very close to 0%, run into pronoun issues. However, if we did, we would be mediator-like about it. And I would call anyone anything they wanted to be called. In fact, if one parent calls a child Junior and the other parent calls the child Bo, when I'm talking to that parent, I'm going to call the child Bo, and when I'm talking to the other parent, I'm going to call the child Junior. So names are labels that we prefer for ourselves. As mediators, I want you to feel as comfortable with me as possible, and certainly starts with going with first names. By the way, they have been Mistered and Mrs. to death by the time they get to us. I found that it's really, with extremely rare exceptions, it's not necessary or helpful or even appropriate. Not that it's inappropriate, but it's not helpful to ask somebody, can I call you by your first name? Because you're almost, if you're not comfortable just going straight to the first name, then that's fine. But if you just go straight to the first names, you will start building rapport that much faster. And in fact, I want to know what do your friends call you, especially if you have either a name that commonly has a nickname, even like Michael might be Mike. If you have a name, I would say, what do your friends call you? And is it okay if I call you that? Yes. Okay, we're going to start building some crazy rapport right there. I wanted to talk about the trainings. Practical portion of the training is sitting in on the morning pre-mediation micro trainings. This is when we talk about the 2 or 3 mediations for the day, and we go into detail about strategy and things like that. It's a great way to get oriented into the program. Also, you'll need to also get a security clearance from the courts. That's free. And then you'll be able to do observations. You're going to observe a couple of mediations. And then your first mediation, we're going to spend some extra time sort of debriefing with you, making sure all your questions are getting answered and things like that. And then you're going to be co-mediating. And since we co-mediate, you're never going to be out there on your own. Later on, once you're experienced and you're comfortable, and let's say your co-mediator, something comes up and your co-mediator calls out sick, then you might be on your own. But that would be later on, and not until you're comfortable. And that's not our preferred. Most people prefer to co-mediate. Okay, so we have administrative processes, mediation processes, and then we have the stages of mediation. There's just lots and lots for us to talk about. There's so much to come, obviously, at this point, but I really appreciate your feedback. We'll put together some little quizzes to refresh your memory and try to get certain key concepts to stick. I'm available. I usually prefer text first if you want to call me, only so I can get off the phone, especially in the morning, so I can get off the phone and then call you back. Questions, comments, feedback. Let me just open it up to you, because I don't know about you. I'm tired of hearing my voice.
Well, I would say that I've enjoyed the first night. I learned a lot. I have 2 pages of notes. I'm looking forward to the resources that you send us. The one thing that I know will be helpful for me, especially not being in California right now or in Los Angeles County right now, is just somewhat of a layout of the court system, because I did write out, specifically the dependency court system. In the court system that I'm currently a part of, family law and dependency court are all in one. And our district is very small compared to some of the larger districts within the country. So it would be helpful for me, at least, to know a little bit more about the family law distinction versus the distinction between the family law court system as well as the dependency courts.
Yeah, so Randy, I really enjoyed this. I think it was a great overview. It was a lot of material in a really short time. I like the sort of the approach to the training, and I think for me particularly, I think a lot of this would kind of come together. I think you've planned this at some point, just kind of in the observation, kind of to really get a feel for what this kind of looks like. So I'm kind of looking forward to doing that. But I just thought you really touched on some great aspects of the program, and it was really interesting just hearing about kind of the origins. And clearly, this is something very special. So it's very exciting to be coming a part of it. So looking forward to it.
Thank you so much, Randy. I would like to get a little bit more information or learn more about the distinction between the dependency courts and the family law courts.
Maybe let me just take a minute and share a little bit about that right now, as my dog is starting to cry because it's his. Yes, I know, buddy. It's time to eat dinner. There's 60 family law courtrooms in LA County. There's 30 dependency courts. Parents who are getting a divorce or whatnot have a lot of reasons to go to family law court. That's for all the family issues. Then when there's been harm or credible risk of harm to a child, including neglect, it goes from the family law over to the dependency. Now, it doesn't have to move from family law to dependency. It can just go from, fist fight in the front of the school, or in the kitchen to the dependency court, and bypass the family. It doesn't have anything to do with the family law court. Now, if there's a divorce in progress, for example, after they have to go to the dependency court. Dependency court trumps everything. They've got to go through that process, exit the process successfully. Then, if they have some business at the family law court, they'll go back to the family law court and take care of that, whether that's child support or spousal support, some financial issues, which we don't handle at dependency, or whether that is, a divorce or other types of issues would be handled at the family law court. So dependency court is for parents who are losing custody of their kids. They're, temporarily. There's no physical custody when a case is open because the court has jurisdiction of the children. So there is no custody. They may be in foster care during that time. They may be, with a grandparent or any family member that can be found. Does that give you a little bit more context?
It definitely does for me.
I think the morning meetings are amazing because you're going to really find out what issues we focus on. Then you see what it actually looks like to do. Mm-hmm. I sometimes use the term Padawan because that's like the new trainees that are going to become Jedi Knights in Star Wars. Shows you what a geek I am. So that's what I'm talking about if I ever refer to you as Padawan. Because to me, mediators are the medicine. You're the best thing in the whole world. You're what the world needs. And, I just, like Jedi Knights, it's just really important to try to get you as much knowledge and give you every opportunity to succeed. So, it warms my heart to see you and welcome.